Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 194. I hope everyone has stayed well and safe in the 24 hours since we last put out a podcast. A couple of months ago, I was asked to do a talk to the Employment Lawyers Association for one of their induction courses for newly qualifieds, and I was asked to talk about redundancy and specifically the handling of individual redundancies as opposed to collective redundancies. I was very happy to do this, and part of the reason is that I think it's something that's going to become a feature of every employment lawyer's life for the next 2 years at least. There was an estimate done last month. I saw that something like 2.7 million jobs were at risk of redundancy already, and 37% of employers were considering redundancies, according to an ACAS survey. Anyway, one of the points that I was making to those who attended the talk was the need to apply the law to redundancy situations. The point was drummed into me at university where I studied employment law. I think it was called labour law in those days. It was a fantastic time to be an employment lawyer because you had the Thatcher strike reforms and trade union laws going through. So it was a really topical time to be an employment lawyer. Anyway, sadly, redundancies were very much of a feature of working life. And after crashing and burning in one tutorial on the subject of redundancy and what amounted to redundancy, it was a lesson never lost to me that you needed to know the definition of redundancy properly. Anyway, I was making a point along these lines to the people attending the lecture, and the case I want to talk about in the podcast is slap bang on point. So the case I'm talking about is Barclay Catering Limited and Mrs. Jeanette Jackson. Well, first things first, I don't know whether it's Berkeley or Barclay. I'll probably change intermittently. Or anyway, we'll go with Barclay, shall we? And Jeanette Jackson, do you think she gets fed up with people making jokes about her name? Anyway, I wouldn't do that, would I? But the case is an EAT case. It's an appeal against an unfair dismissal claim where the Employment Tribunal had found against the employer. It looks quite like it was probably quite a lively hearing from the summary of the facts in the EAT's judgment. Background is that the employer provides catering and event management services. The claimant, Mrs. Jackson, joined in 2013 and by January 2016 was managing director. She took the role over from the owner of the business, Mr. Patel. There were something like 9 direct reports going into the managing director role. A year later, Mr. Patel started to increase the time he spent in the business. He had started to take against Mrs. Jackson and he excluded her from activities and he disparaged her to staff. And the tribunal recorded that he agreed frankly that this was the case in his oral evidence and that he had set out to undermine her. In early 2018, he then announced that he intended to take over from her as MD. This then escalated or developed, and Mr. Patel announced he was going to come back as the CEO. He was going to take control of the decision-making, and that the MD role performed by Mrs. Jackson would be redundant. The redundancy process seems to have gone quite badly too, in that the final redundancy meeting never took place, there was no appeal mechanism made available to her, and there seems to be no attempt to fit her into a new role that was being created of events director. Mrs. Jackson claimed unfair dismissal. Colour me unsurprised. The claim was that there was no redundancy, and even if there had been a redundancy, there was no fair redundancy process. Amongst other things, she pointed out that the new role, that of events director, had been offered to a new recruit rather than to her, and this was happening at precisely the time that she was being made redundant. She therefore claimed the company acted in bad faith in dismissing her, and without following a genuine process. The defence was that there was either a redundancy or some other substantial reason consisting of a business reorganisation. The parties at the directions hearing agreed that the list of issues included 1. Was there a genuine redundancy situation in respect to the claimant's position as managing director? 2. If so, was the decision to dismiss by reason of redundancy reasonable? 3. If there was no redundancy situation, was there some other substantial reason justifying dismissal? But there were other questions as well, but those were the key ones. The Employment Tribunal's decision was that there was no redundancy and that there was no business reorganisation constituting some other substantial reason for dismissal. Therefore, the tribunal found against the company, didn't even get into the procedural fairness or the overall reasonableness of the dismissal. There was no reason to dismiss. Well, the EAT started by reminding itself of the relevant provisions, Section 1391 of the Employment Rights Act 1996. This provides that there is a redundancy situation, quote, if the dismissal is wholly or mainly attributable to the fact that the requirements of the business for employees to carry out work of a particular kind, or for employees to carry out work of a particular kind in the place where the employee was employed by the employer, have ceased or diminished, or are expected to cease or diminish. Breaking that down, there needs to be a dismissal. It needs to be attributable to a reduction of work of a particular kind, and that's either generally throughout the business or specifically in relation to a particular location. Well, the Employment Tribunal reasoned that Mr. Patel was now putting more time into the business. As such, this meant that there was no diminished need for the MD role. That role continued with Miss Patel in it. Indeed, there was evidence, according to the Employment Tribunal, that the role was overworked and under-resourced. The Employment Tribunal believed that this was not a situation where there was a diminishing need for a managing director or an MD function. It was a deliberate and admitted attempt to undermine the person who was fulfilling the role of the managing director at the material time. So there was no general diminution in need for senior staff in the respondent's business. Similarly, there was no financial pressure on the company to cut costs, because there had in fact been an increase in sales during the claimant's employment. There was also no material reduction in outgoings or headcount at the time of the dismissal. Pausing there for a moment, what do you think the EAT's decision was? Well, consistent with going back to look at the detail of the statute, the EAT quickly decided the tribunal had gone wrong. They pointed out that the alleged undermining of Mrs. Jackson was simply not relevant to whether or not a redundancy situation existed. A redundancy situation either exists under Section 139 or it does not. The entire employer is entitled to organise its affairs, so that a requirement for employees to carry out particular work diminishes, so that if the work diminishes, a redundancy situation exists. The motive of the employer is irrelevant to the question of whether a redundancy situation exists. The EAT then pointed out that the issue of the employer's motivation for the dismissal was relevant. It's just not relevant whether or not a redundancy situation existed. As the EAT said, you could have a redundancy situation affecting someone who was dismissed without that just being the reason for the dismissal. Think about it. It's pretty obvious if in the middle of a redundancy situation someone is dismissed for gross misconduct unconnected with the redundancy, then it's clear that although the redundancy situation exists and they're being dismissed, they're not being dismissed because of it. Moreover, the EAT pointed out that even if the reason for dismissal was redundancy, it is still up to the tribunal to decide whether the employer's decision to dismiss was reasonable or unreasonable on that basis. In my terms, the tribunal had, in trying to establish whether or not there was a redundancy situation at all, taken into account matters relevant to the next question, which was, given that a redundancy situation exists, was that the reason for dismissal, and did the employer act reasonably in all the circumstances? Drawing on the earlier case of Safeway and Burrell, factors such as the lack of any headcount change and cost-cutting might be relevant to the reasonableness in the decision to dismiss, but not whether there was a redundancy situation in the first place. Berkeley had arranged its affairs so that Mr. Patel, with or without other existing employees, absorbed the work of the MD, whatever his reasons for doing so were. So there was therefore a diminution in the requirement of the business for employees to carry out work of the kind that she did, and accordingly a redundancy situation. What about the other aspect of the appeal? The employer was arguing that the dismissal was justified as there'd been a business reorganisation. That was the arrival of Mr. Patel taking over the role, albeit some of her duties had been taken on by her colleagues. Now, bear in mind that in order to show that a reorganisation is a sufficient reason to justify dismissal, according to Kerry, Foods and Lynch, there needs to be a discernible advantage to the business from the reorganisation, but it's not necessary to have a particular level or quantum of advantage or improvement. In our case, the Employment Tribunal found there was a lack of justification for any reorganisation. There was no evidence of poor performance by Mrs. Jackson. The reason for dismissal related to her and not any business restructure. The company tried to make the same argument that it had made in relation to the redundancy argument. Mr. Patel was taking over. That by itself was sufficient to be the business reorganisation, and she'd been dismissed because of that, i.e. the business reorganisation. But the AT said it did not read the tribunal's decision in the same way. It said that the finding by the Employment Tribunal had been that the reorganisation did not amount to a substantial reason for dismissal. Therefore, the appeal on that point failed. The AT accepted the tribunal was entitled to find that the claimant had been dismissed for personal reasons and not because of a dismissal necessitated by a business reorganisation. And the case was remitted, with the AT making a declaration that there was a redundancy situation because of the diminution in the company's requirement for employees to do work of the kind done by Mrs. Jackson. In fairness to the Employment Tribunal, you can see how easy it would be to go wrong in this sort of situation. I think the EAT's insistence on looking at the terms of the statute is right. It's not a case of identifying whether there is a diminution in the amount of work to be done by the managing director. That's not the relevant test. The test is whether there was a reduced need for employees to undertake work of the particular kind done by Mrs. Jackson. And the answer to that was yes. Now, of course, the clearest example of this came in the Noble and House of Fraser case a few years back, where the employers were dismissing employees and replacing them with contractors. There was no drop there in overall headcount, but there was a redundancy situation because the number of employees being asked to do the relevant work had dropped. I think the Employment Tribunal's error and the EAT's correction is very helpful in showing the dividing line between factors relevant to whether or not there is a redundancy situation and factors relevant to the fairness of the dismissal. The EAT has helpfully clarified that either the redundant situation falls within the definition of redundancy in the legislation, or it does not. Why it falls into the definition is not relevant to whether it falls into the definition. Conversely, however, employees are not left without a remedy. Just because a redundancy situation exists does not prevent an employment tribunal considering whether it is fair to dismiss the employee in these circumstances. That's, of course, where issues about motivation and so on will come into play. I wonder in this case whether this victory will prove to be a limited or temporary one for the company. The summary of the case by the EAT reveals lots of significant weaknesses apparently in the respondent's case, and one imagines that a tribunal will be unlikely to take kindly towards an employer who admits, frankly, undermining a senior employee, failing to trial her in a new senior role that is being set up, and which has no appeal stage for the redundancy process. Finally, the comments about business reorganisation. Well, I think they're quite helpful. Business reorganisation is often pleaded as an alternative to redundancy, given the strict requirements of the legislation and the way sometimes it's difficult to know the facts will fall. Here, the Employment Tribunal had been correct to find that whether or not there was a business reorganisation, that wasn't why she was dismissed. She was dismissed for reasons personal to her. It was nothing to do with the reorganisation. In my terms, they got rid of her so there was a business reorganisation. It wasn't the other way round. Anyway, as always, thanks very much for listening. I hope everyone stays safe until the next podcast. And it just confirms for me to remain that no employment lawyers were harmed or mistreated in the making of this podcast in any way. Thanks very much for listening. Cheers.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.